You're all welcome to today's News Deep Analysis. This is not noise. This is serious. What you are about to hear can change how you see the Nnamdi Kanu case. If you care about justice in Nigeria, stay with me till the end. If you care about fair trial, stay with me. And if you want clear facts without drama, you're in the right place. Please like this video so more Nigerians can see it. Subscribe to the channel. Turn on your notification bell so you don't miss important updates like this. Now let's get straight into it. Senior lawyer Maxwell Opara has revealed a new twist. A twist many Nigerians did not expect. According to him, Nnamdi Kanu is facing a major block in his appeal. Not from the public. Not from politics. But from the system itself. Opara says the court has denied Kanu access to key electronic files. These are files needed to prepare his appeal. Without these documents, an appeal becomes weak. Without them, the defense is forced to work in the dark. This claim has sent shock across many legal minds. Because in normal legal practice, appeal is built on records. Court records. Trial documents. Evidence files. Rulings. Everything that happened before judgment. When any of these are missing, the appeal process suffers. Maxwell Opara made it clear that this is not about emotions. It is not about sympathy. It is about procedure. Law is not guesswork. Law depends on access to facts. He explained that electronic files are now a core part of modern trials. Many court records are no longer only on paper. They are stored digitally. If access is blocked, lawyers cannot fully review what happened in court. This is where the concern deepens. Nnamdi Kanu was sentenced to life imprisonment on the 20th of November. That date matters. Because from that day, the right to appeal begins. Appeal is not a favor. It is a legal right. Soon after the sentence, Kanu was moved to Sokoto prison. Far from Abuja. Far from the main legal teams. Far from easy access. Now combine these facts together. A life sentence. A distant prison. And denied access to electronic files. This is why Opara calls it a serious problem. He argues that preparing an appeal without full records is like fighting without knowing the charges clearly. You may know the judgment, but you do not know every detail that led to it. He also stressed that time is critical in appeal matters. Delays weaken cases. Missing documents cause delay. And delay can quietly kill an appeal. This is not the first time Nigerians have raised concerns about the Kanu case. From arrest to trial to judgment, the case has remained sensitive. Every step has been watched closely, both inside and outside Nigeria. But this new twist feels different. Because this time, it is not about what Kanu said. It is not about protests. It is not about politics. It is about access to files. Opara insists that denying electronic records sends the wrong signal. It creates doubt. It raises suspicion. And it damages trust in the process. He also warned that justice must follow due process, not shortcuts. When courts appear to block access, even unintentionally, people begin to question fairness. Many Nigerians are now asking simple questions. Why deny access to files? What is being delayed? Who benefits from the delay? These questions are growing louder. For a case of this size, silence creates fear. And fear creates tension. This is why this revelation matters. Because it touches the foundation of justice. And once that foundation shakes, confidence falls. This issue did not come out of thin air. It came after Maxwell Opara visited Sokoto prison. That visit is very important. Because it changes everything. This was not a rumor. It was not second-hand talk. It came after direct contact. After seeing the condition. After speaking from experience. Sokoto prison is far from the center of legal activity. It is far from Abuja. It is far from the courts handling the appeal. It is far from where most legal teams operate. When Opara went there, he saw the reality. He saw how hard access has become. He saw the gap between the court process and the person involved. After that visit, his message became stronger. more urgent, more serious. This is why Nigerians must pay attention. In Nigeria, justice is not only about judgment. It is about process. How a person is treated after judgment matters. How appeal rights are handled matters. When someone is sentenced to life imprisonment, the appeal stage becomes the last major legal hope. That stage must be clean. It must be open. It must be fair. But what happens when access becomes limited? From Sokoto prison, communication is slower. Document sharing is harder. Legal coordination takes more time. Every delay adds pressure. Now add the issue of denied electronic files. This is where the worry grows. Appeal lawyers need full records to work properly. They need to read everything. Every ruling. Every objection. Every response. Without these, appeal becomes guesswork. And guesswork has no place in law. This is why many Nigerians feel uneasy. Because this looks like a system closing in. Slowly. Quietly. Opara's visit made one thing clear. This is not just a legal file problem. It is a human access problem. A man sentenced to life is now far away. Separated from easy legal reach. And now, according to his lawyer, separated from key documents. That combination is dangerous. Supporters of the government argue that the law is strict. They say rules must be followed. They say security matters. But even strict systems have standards. Even strong laws must allow fair defense. This is why Nigerians from different sides are talking. Not only supporters of Kanu. Not only critics of the government. But neutral observers. Because if appeal access can be limited this way, it sets a worrying example. Today it is a high-profile case. Tomorrow it could be a silent case. One nobody hears about. Nigeria has a history with justice concerns. People remember past cases. Cases delayed for years. Cases lost in paperwork. Cases forgotten in prison walls. This is why trust is fragile. Maxwell Opara's visit to Sokoto prison brought the issue closer to reality. It moved it from theory to ground truth. He did not speak as a distant commentator. Someone who saw. Someone who returned with concern. That is why his words carry weight. This is not about creating chaos. It is about protecting process. Because once process breaks, outcomes lose meaning. Many Nigerians now feel this case is becoming a test. A test of fairness. A test of transparency. A test of whether the system listens. The life sentence on November 20th was heavy. The move to Sokoto prison added more weight. This new appeal issue adds pressure. And pressure creates reaction. This is why Chapter 2 matters. Because it shows why this issue is not distant. It is close. It affects trust. It affects belief in justice. And once belief is shaken, it is hard to rebuild. The story is moving fast. And Nigerians are watching closely. Now the focus shifts to what comes next. Because this case has reached a point where silence is no longer safe. After the prison visit. After the claim of denied electronic files. After public attention begins to rise. The system must respond. In law, appeal is not a privilege. It is a right. And rights must be protected, not delayed. If access to electronic records continues to be blocked, the appeal process will suffer serious damage. Not just for Nnamdi Kanu, but for the image of justice itself. This is where pressure begins to grow. Legal pressure, public pressure, and quiet pressure from observers who may not speak openly. Maxwell Opara has placed the issue on record. Once something is on record, it cannot be ignored forever. Courts respond to records. History responds to records. The authorities now face a simple choice. Open access and allow the appeal to move forward properly. Or continue the delay and face deeper questions. Either way, the world is watching. This case has crossed local boundaries. It is no longer only a Nigerian issue. It is now part of a wider discussion on rights and due process. That is why every step matters. Nnamdi Kanu's life sentence on November 20th changed the tone of the case. The move to Sokoto prison changed the structure. This appeal issue may change the direction. Appeal cases are often quiet. They do not come with noise. They come with files, arguments, and patience. But when access is blocked, silence turns into suspicion. Many Nigerians are now waiting for clarity. Not slogans. Not arguments online. But clear action. Release the files. Allow the lawyers to work. Let the appeal stand on full facts. That is how confidence is rebuilt. This moment will be remembered. Not because of anger, but because of how the system reacts. If fairness is shown, trust grows. If fairness is delayed, doubt spreads. This is not about winning or losing a case. It is about protecting the meaning of justice. Cases end. Judgments change. But records remain. What happens now will shape how future cases are judged. Not in court, but in the minds of Nigerians. This is why this story matters. This is why it cannot be rushed. And this is why it must be followed closely. We will continue to watch. We will continue to analyze. And we will continue to ask questions. Because justice works best when the light stays on. This case has reached a point where it can no longer be treated like normal news. It has moved beyond headlines. It has entered the space where history begins to take notes. What we are seeing is not just a legal struggle. It is a test of structure. A test of fairness. A test of how strong Nigeria's justice system really is when pressure rises. Nnamdi Kanu's life sentence on November 20th was final in sound, but not in law. Because the law allows appeal. And appeal only works when access is complete. That is the heart of this matter. When a man is sentenced to life, every legal step after that must be clean.
No confusión. No hidden doors. No blocked paths.
The claim that electronic files needed for appeal are being denied is serious. It raises questions that cannot be brushed aside. Questions about balance. Questions about openness. Questions about intent. This is why Maxwell Opara's words matter. Not because of who he is, but because of what he pointed out. He did not speak in anger. He spoke in concern. Concern for process. Concern for fairness. Concern for the future of legal trust. The move to Sokoto prison added another layer. Distance always changes access. Distance always slows things down. In legal matters, slow movement can change outcomes. When distance meets denied files, the problem doubles. Nigeria has seen many cases over the years. Some loud. Some quiet. Some forgotten. But cases like this stay alive because they touch nerves. They touch identity. They touch belief. They touch fear. Fear that the system may not hear everyone equally. Fear that procedure may bend under weight. Fear that silence may replace clarity. This is why neutrality is important now. This is not the time for blind support or blind rejection. It is time for careful watching. The appeal process must speak for itself. Through actions. Through access. Through fairness. If the files are released and the appeal moves forward cleanly, confidence will rise. If delays continue, questions will grow louder. Justice does not fear questions. Only weak systems do. This moment will shape future trust. Not only in this case, but in others yet to come. Young Nigerians are watching. Legal minds are watching. Observers outside the country are watching. They are not looking for drama. They are looking for standards. Standards that say no matter who you are, no matter the charge, the process remains open. This is how strong systems survive. By allowing light in. By allowing scrutiny. By allowing fairness to show itself. The Nnamdi Kanu case will one day end. Every case does. But the lessons from it will remain. How appeal rights were handled. How access was managed. How concerns were answered. These details matter more than slogans. At times like this, Silence from institutions speaks loudly. And action speaks even louder. The path ahead is simple in principle, even if complex in law. Allow access. Let the appeal run its course. Let justice breathe. Nigeria does not need perfection. It needs consistency. It needs clarity. It needs confidence. This is not about choosing sides. It is about choosing standards. Because when standards are protected, justice becomes stronger than any single case. And when justice stands firm, the nation stands firmer with it.